The evidence and arguments have now been concluded. It is now time for me to instruct you to give you the law, the judges of the facts, and to excuse two of you. We'll go to lunch, 1 hour, and we'll begin our deliberation. Please descend into the books. Once you get your book, there's a stop sign in the middle. Remember, we have to share with our neighbor. There's a stop sign. Open it up. 3.1. 3.1. 3.1. 3.1. 3.1. Listen, if I say something, you don't have to stop me. 3.1. Yes. Does everyone have it?
Yes.
Okay, very good. Remember how we did it before? I'm going to read and you read it silently, okay? 1 second. Yes, please. Members of the jury, the evidence and arguments in this case are finished, and now I'll instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. When you decide about any fact in this case is fine. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the laws I give it to you, and that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption the defendant is innocent. This presumption continues throughout the trial, entitles the defendant to a verdict of not guilty, unless you were satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor not proving every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair and honest doubt, growing out of the evidence or lack of evidence, not merely an imaginary possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that a doubt is reasonable, after carefully considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted in the evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments and commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. Let me read that again. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide the case based only on the evidence admitted during this trial. Turn the page. The prosecutors introduce evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about the other evidence in the case. You may consider this statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all the evidence that you believe. There's been some evidence that the defendant ran away and hid after the alleged crime. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of consciousness of guilt. You must decide whether the evidence is true. You must decide whether the evidence is true, and if true, whether it shows the defendant had a guilty state of mind. If you believe that a witness previously made a statement inconsistent with his the evidence has been offered that one or more witnesses in this case previously made statements inconsistent with the testimony of the trial, you may consider such an earlier statement in deciding whether the testimony of this trial is truthful and determining the facts of this case. Okay, if you believe that a witness previously made a statement inconsistent with his or her testimony at this trial, the only purpose for which the earlier statement can be considered by you in deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the witness said earlier is true. When the lawyers agree on a statement of fact, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts or circumstances and evidence. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything the witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witnesses. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was a witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or personal interest in how this case is decided? Have there been any promises, suggestions, or other influence that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree. You must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think that someone is lying or simply mistaken. People seem hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from the witnesses, from witnesses. Miranda Irwin, who gave her opinion as an expert in forensic investigation. Heather Vita, who has given her opinion as an expert in DNA analysis. Dr. Jeffrey Jentz, who has given his opinion as an expert in anatomical forensic pathology. And Lieutenant Leo Gerard, who has given his opinion as an expert in forensic analysis of cell phones. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he or she gave for his or her opinion and whether those facts are true. You should also think about whether the expert's qualifications. You should also think about the expert's qualifications and whether his or her opinion makes sense when you think about all the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witnesses. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about January 1st, 2018 within Wayne County. Elements of the charge. Now these are the elements that I'm about to give you. The defendant is charged with first-degree felony murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Gabrielle Barrett. That is, that Gabrielle Barrett died as a result of multiple traumatic injuries. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Gabrielle Barrett, or he knowingly created the very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, that when he did the act that caused the death of Gabrielle Barrett, the defendant was committing or attempted to commit or helping someone else to commit the crime of child abuse in the first degree and or torture. For the crime of child abuse in the first degree, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant is the parent or guardian of the child, or had care or custody of or authority over the child when alleged, had care or custody of or authority over the child when the abuse allegedly happened, regardless of the length of time the child was cared for by, in the custody of, or subject to the authority of that person. The defendant either knowingly or intentionally caused serious physical or mental harm to the child. The child was at the time under the age of 18. For the crime of torture, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant had custody or physical control over the complainant. This means that the defendant used force or threat of force either to confine the complainant, and in this matter, the complainant is alleged to be Gabrielle Barrett, opposed to her name not appearing, by interfering with her liberty or to restrict the complainant's freedom of movement. The defendant exercised custody or physical control over the complainant without her consent or without lawful authority to do so. At the time the defendant had custody or physical control over the complainant, the defendant intentionally caused great bodily harm or injury or severe mental pain or suffering to the complainant. The defendant intended to cause the complainant to suffer cruel or extreme physical pain or mental pain and suffering. The prosecutor does not have to prove that the complainant actually suffered any pain. And fourth, that the killing was not justified, excused, or done in a circumstance that would reduce it to a lesser crime. The defendant, you may also consider the lesser crime. The defendant is charged with the crime of second degree. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Gabrielle Barrett. That is, that Gabrielle Barrett died as a result of multiple traumatic injuries. And second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Gabrielle Barrett, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, killing is not justified, excuse me, under the circumstances or usage of a lesser crime. You may think about all the evidence. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the type of wounds inflicted, the words of the defendant, and any other circumstances surrounding the alleged killing. The defendant is also charged with the crime of first-degree child abuse. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that Brad Edward Fields had the care and custody of Gabrielle Barrett. Second, that the defendant either knowingly or intentionally caused serious physical harm or serious mental harm to Gabrielle Barrett. By serious physical harm, I mean any physical injury to a child that seriously impairs the child's health or physical well-being, including but not limited to brain damage, a skull or bone fracture, subdural hemorrhage or hematoma, dislocation, sprain, internal injury, poisoning, burning, or scald, or severe cut. And third, that Gabrielle Barrett was at the time under the age of 18. The defendant is charged with the crime of torture. To prove this charge, the prosecutor must prove beyond a reasonable doubt. The defendant is charged with the crime of torture. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant had custody or physical control over Gabrielle Barrett. This means that the defendant used force or the threat of force either to confine Gabrielle Barrett by interfering with her liberty or to restrict Gabrielle Barrett's freedom of movement. Second, the defendant exercised custody or physical control over Gabrielle Barrett without her consent or without lawful authority to do so. Third, at the time the defendant had custody or physical control over Gabrielle Barrett, he intentionally caused great bodily injury or severe mental pain or suffering to Gabrielle Barrett. Great bodily injury means causing a serious impairment of a bodily function, which includes any of the following: a loss of a limb, a foot, a hand, a finger, a thumb, an eye, an ear, or loss of the use of that part or those parts. Loss of substantial impairment of the bodily function. Severe visible disfigurement or measurable brain or mental impairment. Or means internal injury, poisoning, serious burns or scalding, severe cuts, or multiple puncture wounds. Severe mental pain or suffering means a substantial change in mental function that can be perceived by another person. It must have been caused by the defendant in one or more of the following ways: intentionally causing great bodily injury to Gabrielle Barrett or threatening to cause great bodily harm to her, administering mind-altering substances or performing a procedure that would disrupt Gabrielle Barrett's sense or personality or threatening to do so, threatening Gabrielle Barrett with imminent death, or threatening that another person would imminently be killed subjected to great bodily injury, or given a mind-altering substance meant to disrupt the senses or personality. And fourth, that the defendant intended to cause Gabrielle Barrett to suffer cruel or extreme physical pain or mental pain and suffering. The prosecutor does not need to prove that Gabrielle Barrett actually suffered any pain. The defendant is charged with the crime of conspiracy to commit child abuse first degree. Anyone who knowingly agrees with someone else to commit a conspiracy to commit child abuse first degree is guilty of a conspiracy. To prove the defendant's guilt, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant and someone else knowingly agreed to commit conspiracy to commit child abuse first degree. Second, that the defendant specifically intended to commit or help commit that crime. And third, that the agreement took place or continued during the period of time from September the 1st, 2017 to January 1st, 2018. Now let me define the crime of child abuse first degree. First, that Brad Edward Fields had the care and custody of Gabrielle Barrett. Second, that the defendant either knowingly or intentionally caused serious physical harm or serious mental harm to Gabrielle Barrett. By serious physical harm, I mean any physical injury to a child that seriously impairs a child's health or physical well-being, including but not limited to brain damage, a skull or bone fracture, subdural hemorrhage or hematoma, dislocation, sprain, internal injury, poisoning, burn, or scald or severe cut. Third, that Gabrielle Barrett was at the time under the age of 18. An agreement is a coming together, a meeting of the minds of two or more people, each person intending and expressing the same purpose. It is not necessary for the people involved to have to make a formal agreement to commit the crime or to have written down how they were going to do it. In deciding whether there was an agreement to commit a crime, you should think about how the members of the alleged conspiracy acted and what they said, as well as all the other evidence. To find the defendant guilty of conspiracy to commit child abuse in the first degree and or child abuse in the second degree, you must be satisfied beyond a reasonable doubt that there was an agreement to commit child abuse in the first and or child abuse in the second degree. However, you may infer that there was an agreement from the circumstances such as how the members of the alleged conspiracy acted. The defendant is charged with the crime of conspiracy to commit child abuse second degree. Anyone who knowingly agrees with someone else to commit conspiracy to commit child abuse second degree is guilty of conspiracy. To prove the defendant's guilt, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant and someone else knowingly agreed to commit conspiracy to commit child abuse second degree. Second, that the defendant specifically intended to commit or helped commit that crime. And third, the agreement took place or continued during the period from September 1st, 2017 to January 1st, 2018. Now let me define the crime of child abuse second degree. First, that Brad Edward Fields had the care and custody of Gabrielle Barrett. First, that Brad Edwards Fields had care or custody of or authority over Gabrielle Barrett when the abuse allegedly happened, regardless of the length of time the child was cared for by, in the custody of, or subject to the authority of that person, and that the defendant knowingly or intentionally did an act that was cruel to Gabrielle Barrett. Cruel means brutal, inhumane, sadistic, or that which torments regardless of whether harm results. And third, that Gabrielle Barrett was at the time under the age of 18. In this case, the defendant is charged with committing felony murder and or murder in the second degree and or child abuse first degree, and torture and or conspiracy to commit child abuse first degree and or conspiracy to commit child abuse second degree. Anyone who intentionally assists someone else in committing a crime is as guilty as a person who directly commits it and can be convicted of that crime as an aider and abetter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed, either by the defendant or someone else. It does not matter whether anyone else had been convicted of that crime. Second, that before or during that crime, the defendant did something to assist in the commission of the crime. Third, at the time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and proper consequence of the commission of the crime intended. It does not matter how much help, advice, or encouragement the defendant gave. However, you must decide whether the defendant intended to help another commit the crime, and whether his help, advice, or encouragement actually did help, advise, or encourage the crime. Case summary by prosecution, defense, you waived.
Yeah.
Defenses. Do you want to approach?
Oh, okay. Okay.
Even if the defendant knew the alleged crime was planned or being committed, the mere fact that he was present when it was committed is not enough to prove that he assisted in committing it. It is not a crime to discipline a child, a parent or guardian or any, you have that? Juror number 5. Son, what'd you say?
Yes.
Okay. It is not a crime to discipline a child, a parent or guardian, or any person otherwise allowed by law or authorized by the parent or guardian may use force to discipline a child. But this does not mean that any amount of force may be used. The law permits only such force as is reasonable. The defendant is not required to prove that the acts alleged here were reasonable. The prosecution must prove beyond a reasonable doubt that the force used was not reasonable as discipline. When you go to the jury room, you should first choose a four-person. A four-person should see to it that your discussions are carried on in the business like way that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agree on that verdict in the jury room. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions. And do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalty, turn a page. Possible penalty should not influence your decision. It is the duty of the judge to fix a penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your four-person write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officer, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. The court is going to publish all the exhibits to you. That means I'm going to give it to you up front. And you go to the jury room, you will be given a written copy of some of the instructions you have just heard. As you discuss the case, you should think about all my instructions, both those I gave orally and those you also have with you as a law you are to follow. Have I complied with your reading and jury instructions?
Yes. Can we approach for one quick second?
Yes. Go back to expert witness. .10. It's a paper. Do you have it?
No.
Okay, very good. Go back in the beginning where the stop sign is. Have it? The stop sign?
Yes.
Next page. After stop sign, just keep going. 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 It says expert witness. Do you have it?
Yes.
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 I'm going to reread it. You have heard testimony from witnesses. Miranda Irwin, who was given her opinion as an expert in forensic investigation. Heather Vita, who was given her opinion as an expert in DNA analysis. And Dr. Jeffrey Jensen, and I'll get you a corrected one. I said his name wrong. Who has given his opinion as an expert in anatomical forensic pathology. And Lieutenant Leo Gerard, who has given his opinion as an expert in forensic analysis of cell phones. Experts are allowed to give opinions in court about matters they are experts on. May I have a deputy, please? However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he or she gave for his or her opinions and whether those facts are true. You should also think about the expert's qualifications and whether his or her opinion makes sense when you think about the other evidence in the case. Have I complied with the reading and jury instructions at this point?
Yes, Your Honor, thank you.
Yes, Your Honor.
Please take this page out and pass it down. Is my assistant available? Jason Flowers? Pass it down, please. Very good. What the court is going to do, we're going to close your book. This is like, 2 times in a trial is challenging for me. To seat a jury, and then once to seat a jury, to have to excuse 2 potential judges of the facts. This is difficult because you've invested so much time on behalf of this court, the defense, the prosecution. We want to thank you. You paid attention. Really, you did. There was a lot of apprehension initially, but I'd like to thank you so very much for doing your civic duty, standing up as Americans, and being good judges of the facts. But at this time, when your seat number is called, I want you to arise. There's a document in the back. I need you to fill out your information, then knock at the door when you're ready. Okay, that has already been filled out. Okay, excuse me, sir. This is correct. And we need to correct it before. Could you do that, please? I believe a sticky was provided. Can we get this, no, let me write, the correct spelling, Jensen.
Right here.
Okay.
Okay, thank you.
Very good. And those individuals will be seated in the following seats. Madam.
Juror and seat number 6.
6.
Juror and seat number 13.
13. Put the book back. You filled out the documents. I just need you to, you can be excused just to go back in the jury room to get your belongings and leave your badge. Swear the debt. Please step in the jury room, please. Madam Clerk?
Your Honor, are we gonna, instruct the jurors they may be called back?
Just wait.
Okay, thanks.
Swear the jurors, swear the deputies.
Did you swear to keep this jury in a manner prescribed by law?
Yes.
as a preliminary, we do have your information. You will not discuss this with anyone in the event that there's a disability by one of the jurors to not be able to go through a jury service or go to deliberation. Just don't talk to anybody about the case, okay? Very good. Thank you so much. You're going to get your letters on your way out. All rise for the jury. My deputy will give you the expert witnesses that has been corrected. Okay, this is what we're gonna do. Let's come back at 2:15. Sorry, okay, 2:15. Excuse me, please. Just get ready for it. Anyway, 2:15, and we will begin to, and you'll begin to deliberate promptly. Okay, and we're gonna go to 4:30 today. Okay, and in the event that you're unable to, because you know it has been a week-long trial, we will do some deliberations tomorrow. Okay, very good. Not gonna do it when you're ready to go as a group. Take those books in there with you. That's the law you are to follow. When you get back, everything will be set up there with you, all the evidence that has been admitted. Thank you so much. Did you give them the instructions? Please. Court's in recess.